There are a lot of things that are different today. Because it's the internet, we have a lot more communication capability and speed than we ever had before. But in today's world, internet or no internet, one of the biggest factors is fear. We've got more folks getting older, the baby boomers, and they're afraid that they're not going to be able to sustain themselves long term or longer term than where they are now. So they're thinking about selling. On the other hand, lawyers who want to buy a practice now are thinking, well, what are they going to get? They're afraid that the clients won't stay with them once they buy the practice, and they're afraid of buying a pig in a poke. One of the things that you need to do is to think in terms of the buyer's perspective. The buyer is asking, can I afford to buy this practice? Will the client stay with me? Will the revenue stream that the seller has maintained for a number of years stay with me? That's number one. Number two is a question of, if I can't afford to buy the practice today with a lump sum payment right now, so I can extract the seller and the practice is entirely mine, how am I going to get the financing? Today's world, the banks are requiring more involvement of the buyer. They're willing to lend less than they used to in the past. And so now you've got to think about the seller financing. And if the seller is going to accept payment terms, as is the case often, what kind of collateral is the buyer going to have? So now you have the issue of, is it a lump sum payment all now up front, or is it payout over time? And the practice of law, the sale of the practice of law, is no different than the sale of a car distributorship or a manufacturer or what have you. You've got to get the buyer and the seller together where their financial situations harmonize. One of the things that makes practice sales more difficult today is mobility. You've got the mobility of the lawyers, but you also have the mobility of the clients. So lawyers who are buying a practice want to make sure that they get what they think they're getting. They want to make sure that the clients of the selling lawyer stay with the practice. And that requires some astuteness that buying lawyers didn't need in the past. It was always assumed that the clients wouldn't go anywhere, they'd stay with the office and so forth. Today, that's not necessarily true. I think it still is true, but it requires some astuteness on the part of the buyer. In other words, you've got to walk in and you've got to establish a new relationship with the client. You've got to show the client that there's a transition from the seller to the buyer that works. And the buyer has to be no less, amenable, no less likable than the selling lawyer. Because it's in that case when the client won't stay. But if the buying lawyer is as good, as likable as the selling lawyer and creates a relationship, the bond with the client, clients will stay. They're not going to move away, despite the mobility. Branding is always important in marketing. I think we all know that, from Kodak to Xerox to Ford to O'Melveny and Myers to Gibson, Dunn and Crutcher. Branding is important. The buying lawyer, however, can assume the brand of the selling lawyer or create a whole new brand. This is not as difficult as it sounds. It's just a function of the approach that the buying lawyer wants to take. And many lawyers feel that the brand of the selling lawyer is the personal name. And if that lawyer is going to retire from the practice, that brand doesn't transfer over. I disagree. I think the brand does transfer, and I think you can create a new brand that works. In the legal profession, unless you've got a practice that's 100 or 150 years old, the idea of a brand just is not so well entrenched yet that you are going to have trouble in retaining the clientele when you buy a new practice.